Hi, everyone. Welcome to another episode of Hashing Out the Law. I'm your host, Arash Hashemi. In this episode, my guest is Matthew Asbell. He is an IP lawyer. I'm going to let Matthew do all the talking about himself rather than me do it. Hi, Matthew. How are you?
I'm great, thanks. I love to talk about myself. This will be great.
Who doesn't? Who doesn't? But Matthew, one of the reasons I wanted to have you on is because of what you do. But before we go and dive into me asking you questions, let's have the viewers and the listeners learn a little bit about you. Please tell us how you started, who you are, what you do.
Sure. So maybe the best place to start, since your podcast is really about lawyers, is to say I never wanted to be one. My father was a lawyer. It seemed really boring. I couldn't imagine ever wanting to do this for a living. I did everything else. I was in the sciences. I went to med school. Um, I taught computers, and I managed singer-songwriters, recording artists, and released their records.
I have a question before you continue. Did you finish med school?
No, I did not. I finished 2 years of med school.
Okay.
At the end of my second year of med school, during which I had been going to a recording studio once a month to record my original music, I had a finished record. So I had to decide whether I was going to release the record or I was going to take the national boards. And I chose to release the record. Had a bit of success and ended up working for a bunch of other singer-songwriters who saw the success that I had and thought maybe I could replicate it for them. So I did that for about 10 years. Uh, and and basically, I've gravitated around some form of intellectual property one way or another my entire career before becoming a lawyer. And it was when one of the artists I was working with started to get her music into film and television that I learned that, gee, apparently it's lawyers who do those contracts. And gee, I should, if I want to be an artist manager for musicians, I should probably go to law school. So I thought I'd be a music lawyer. Went to law school, found out that my science background qualified me for patent law, and my entrepreneurial background as someone who had run a record label and a management company, uh, was relevant for trademark law. And so I had copyright, trademark, patent, and I decided, okay, that's what I want to do because I care more about what people create than necessarily what type of industry they were in.
Right. I usually ask my guests who are lawyers, when was that moment that clicks in your head that you wanted to become a lawyer? But you already answered that. So let's move on. Um, Now, I actually have a question. You didn't want to be a lawyer. You went to med school. You thought you wanted to be a doctor, but deep down inside, you wanted to be a musician. And you have this record that's complete now, and you decide, do I want to go release the record or do I want to, continue being a medical student and a doctor eventually? At one point, did you say, you know what? I really want to be a musician and I really wanted to do it and maybe this med school thing isn't for me. Was there a specific, I know you said you wanted to release that record, but was there a specific moment, that aha moment?
No, in fact, it was intended to be temporary, right? I figured, okay, I'll not do this now. Maybe I'll take a year or whatever. I'll just see what happens. And that just ended up being a totally different path. I'm one of those people, I was never satisfied doing only one thing. Even as an IP lawyer, I don't only do one thing. I also work as an adjunct professor, for example. Uh, so I was always struggling with wanting to satisfy different aspects of who I am, I guess, in every way, of what my values are. And so no, there was no sort of decision of I want to do this at the exclusion of that. It was rather I want to do this now, and that ended up being I'm never going back.
So where do you teach and what do you teach?
So I have taught trademark law at Fordham Law School in New York. I also teach a seminar when law students go and work at law firms doing IP so that they learn how to, practical aspects of what it's like in a law firm. And then I teach a class called Counseling and Advocacy for Intellectual Property Clients. So that's a class really geared towards how do we help our clients? How do we understand the different ways in which they approach things, their different forms of communication, cultural competency, who they are, what they stand for, and how do we serve them, recognizing they're not all the same.
That's awesome. Um, Now, one of the things we talked off camera is AI. I'm fascinated with AI, and I use it. I use it in different aspects of my life. Um, what about AI when it comes to IP? One example is, all these videos that come out, these people have these celebrities that are AI generated doing something. Um, how do you or how does one protect themselves and their IP against AI and AI replicating whatever they do?
It's a really complicated question,
Right.
and there are so many aspects in which AI interacts with IP, because you have to deal not only with what you can create using AI and maybe who what you have created impersonates, but there's also the AI platform and what it trained on. And so we really have elements of, well, and actually one other thing, right? What is protectable when you use AI to create it? So I think maybe a good way to approach the question is to imagine that I'm an entrepreneur. Or I'll imagine that you're an entrepreneur and you want to launch, hey, a new AI generated podcast called Hashing Out the Law. And this new AI generated podcast called Hashing Out the Law, you're going to use whatever, Chat GPT or whatever generative AI platform, maybe for purposes of generating the graphics for your podcasts, maybe even for the scripts. Um, Maybe even you're going to train it to work with video images of you and have a video avatar, right? That's you. That's talking, even though it's not really you. So we've got to worry about, okay, um, gee, in the course of creating that, did the platform that you've chosen, or the many platforms you've chosen to use, did they train on someone else's rights? Did the script come from someone else's podcast script? Um, and does that violate copyright? That's still a big question mark. Then we've got the output. All right, the output is uh, Arash speaking, and um, and it has your name, image, and likeness. Now it's you, and you chose it to be you, so you could sign off on that. But what if it was not you? What if it was me, and I didn't authorize you to use my image for that purpose, right? I could have something to say about your ability to use my image in a commercial way on your, as the one speaking on your podcasts. Um, and then there's the content. We've got this recorded podcast that we're putting out there, streaming. We've fixed it in a tangible medium. Can we own the copyright in that so that we can prevent other people from copying it or taking snippets of it that or whatever it is that altering it in some way, things that we might not, or publicly displaying it. What might we want to do to stop them? And unfortunately, the current position in the US is that something generated by an AI platform is not protectable as copyright. So while you could come up with a script, or we could record this program, um, and that would be protectable under copyright if we just did it naturally and came up with what we wanted to talk about, et cetera. But if it's done by AI, then that piece, whatever the AI did, is not protectable. So where it's changed is if you've modified it some degree, you've essentially supervised the AI, you've tweaked the results in some way, well, then it starts to have some human creation to it that maybe it can be protectable.
So I think I know the answer to this one, but let's say AI generates the script for this episode, right? And I hand you the script before you read the script. I got the script. This is pretend this is all scripted. And then we actually record the video. Obviously, the video itself, the podcast video, is copyrighted. But since we use the AI generated script, will we have a problem?
Well, I guess when you say that it is copyrighted, the question is what's copyrighted, right? So if you were to take a video recording, right, of an AI generated script, you and I speaking using an AI generated script, the AI generated script is not protectable. We've protected the recording of us speaking, but the words that we spoke are not necessarily owned. Maybe the way in which we communicated, the way our mouths move, the way our hold our hands while we're speaking, maybe some aspects of the video, right? Because those were not created by AI, those would be protectable. But the elements that were not should not be protectable because they are created by AI, which is not human. It stems back to some fun cases where a photographer gave a monkey a camera in the wild and had the monkey take selfies.
I
And
know that case. Yeah, yeah. Let's talk about that case. But hold on, before we jump to that case, I'm going to take my question and add another layer to it. So we generate the script. Me and you have the script before we record this episode. Our episode is copyrighted. The script is in. Somebody else gets a hold of the script, two different people. They record a video using that exact same script. They don't change anything. Obviously the way they speak is different than me and you speaking, but they're saying the exact same thing. Are they infringing on our copyright?
yeah, my take is no. My take is that we don't own a copyright in the script. And so, unless we altered it in some way, if we just use the AI generated script, then what's to prevent them from using the same AI generated script if they were able to create it, or even if they got it from us? It's not entitled to protection. So they can record their own video with the same AI generated script, all other things being different, and we wouldn't be able to stop them.
Wow. Wow. I guess the question comes down to how do you prove that the script was AI generated, right?
Which I think is an interesting question because it's also a challenge for the various government offices that would register these rights. So you're supposed to answer questions as to whether something was AI generated or not, right? And what you're claiming, but um, but largely these government offices are relying on what people say, and so they may or may not have stated the truth, even if they're obligated to. Um, and and even if they are stating the truth, maybe it's a colorable truth, right? As to yes, we did have AI generated, but we reviewed it and made changes to it, even though all we really did was add some commas or right, a word or two.
Right.
Um, right? How much is actually taking it and turning it into expressive, protectable work from this non-protectable computer-generated work?
As a lawyer, I always think like a lawyer, so I'm going to ask the question now on a third layer. You know how we talked about the case with the monkey? We're going to get into that. The camera was given to the monkey. The monkey took the pictures. In our case, the script was generated by AI, but it was done as per my instructions. I actually had to tell the AI to do something. Can I argue that even though the script was generated by AI, it was done at my direction, so it's my work product?
I mean, I think you can argue that. I don't know if you're going to win that argument, but
Okay.
I do think it goes back to other cases that are interesting historically, because, historically, a camera taking a photo was not was not creating something that was copyrightable because you're using a machine to do it. But it was determined in court, right, in cases that okay, you're using this as a tool to create an output. You're making human expressive decisions in the course of you being a photographer. You're picking the angle from where the camera is, and you're making sure the lights are set up just the right way, or you compose the photo. And so there is this artistic expression in a photograph, even though it was created by a machine or through a machine. So I think there's an argument that, the detail that you put into your prompt, right? Maybe you have controlled the AI enough to create the output a particular way. And maybe that's expressive. As of right now, I think that's not the case. Um, and your prompt is protectable, right? That could be protected, but the output generated by the AI, maybe because it's so somewhat far removed from what you've asked for, and so much of it is taken from elsewhere that no, I would not think that it's a very good argument today.
Wow, that's interesting. I could go down a rabbit hole with this, but let's go back to this monkey case. And you correct me if I'm wrong. So this guy gives a camera to a monkey. Monkey takes pictures of himself. Then the guy claims that those pictures are his because he's the one who gave the camera to the monkey. So it's like me giving the prompt to Chat GPT. Um, and let's talk about the case for those viewers and listeners who don't know about this case, because you can correct me on this one as well if I'm wrong. It's a very important case, correct?
Well, I think it's an important case. I don't, and I don't know, I'm not going to recollect all the facts of the case perfectly.
Right,
I remember there was possibly that he was claiming it for himself. There was also a question of whether the monkey could own the copyright. Right. I
right.
think there's different aspects of it, but sure, we can chat about it.
Okay, let's talk about the case. So, uh, pretend I'm your student and you're gonna tell me about this case.
Oh, okay. That's an open-ended question.
Well, all right, no, all right, let's go back. So, we talked about the facts about what it is. What was the outcome of the case? What was the decision of the case, and why is it important?
All right, so the decision of the case is there's no copyright ownership in the photographs taken by the monkey. The monkey is not human and therefore cannot own a copyright. The person who gave it to the monkey didn't necessarily control the monkey, as sort of as you were suggesting, enough that they could claim the expression. So if something created by a non-human, right, if you didn't have enough control over it uh, and it was not created by you, the human, then there is no ownership of it. It is just public domain.
Right. Um, I don't know if I'm comfortable with that. I understand that ideas are not protected, so you could say the idea of giving the camera to the monkey is in itself is not protected. But isn't that sort of like art, right? It's I'm the artist and I think I'm a photographer and I think I'm gonna do this project and I'm gonna give this camera to this monkey and let him take pictures. So I'm the one who actually set it up. I got the monkey, I got the camera, so it should be my work. However, it's not. So what impact do you think that has on artists' uh, work product, not just photographers, but artists in general? And do you think that the court's view might change in the near future?
Okay, I'm bad with these sort of multi-tiered questions. So I'm going to start with your last question because,
Yeah,
and you might have to remind me of the first part of the question. Um, but look, it's being changed, and it's being changed in many ways, right? There's court interpretation, and we're waiting to see how things are going to come out. Um, there is also legislation and regulation, right? And it's not just a U.S. thing. So you have this going on in other countries which don't have the same law or view of the law don't require necessarily that it be created by a human, et cetera. And so they will find things copyrightable, in China or in some other country. Um, so, so we're at a point where there's a lot of change. We don't know what's going to happen. Those of us, we are relying based on the case law of the past, um, and our beliefs and our understanding of the law, as is our Copyright Office, as an example. And they make, they put out questions. They constantly are reviewing this stuff and considering and changing. But as of right now, we can only rely on what has been, right? What's the precedent? And if there's no precedent that says that, hey, there's any ownership of this, unless you humanly tweak it somehow after the fact, then there is no, that's all we have. And then the court will come out and we'll find out, actually, a prompt is enough control. Okay, fine. Then now we'll start to see it.
Right.
There's a greater impact, which I think is really interesting, long term, sort of twofold. And hopefully I can remember everything I want to say here. Let me see if I can do it. Um, First of all, when people create things, do they have an expectation of ownership of it such that they want to and need to be able to stop people from copying? We are operating off this assumption that that's the case, that they want to control the things they create, that's been our history. And that's the benefit. So, right, you want to be able to profit off of what you create. So you create stuff and you want to be able to own it and have a copyright registration, sue people for infringement and collect licensing revenues, etc. So if it turns out, based off, as I would expect it to turn out based on the history, that there's nothing protectable here, then there are all these people who are, and everybody in the past 2 years, right, is creating stuff with AI. All these people probably doing that with a thought that what they've got as the output is theirs. That's not, and they're not going to be able to do much about it. The other, like, longer term impact of it is kind of interesting is we have this concept called the public domain. The public domain typically is the works that are no longer protected as copyright, because copyright's for a limited term. So usually it's the life of the person who created the work plus 70 years, at least in the United States. So a really long time. And we can thank Walt Disney for that. But after that term is over, whatever was created is now dedicated to the public, and now anybody can use it as fodder for the future. Great. So you can create things based on off this old stuff. If the newly creative, generative AI generated works are not protectable, they're essentially public domain, which means there's this ginormous expansion of the public domain, was all of a sudden there's all this unprotected work out there, which could be great for inspiration and you could grab, although there's going to be the pitfall of how do I know what I can use and what I can't? And you already have this problem with people on the internet. Like, many lay people think they can just go grab an image off the internet and use it and do whatever they want with it. They don't recognize that they're violating a copyright when they do that. And so they do it and they get themselves in trouble. And there's all sorts of law firms that's all they do is go after people who do that sort of thing. And they do that. Why? Because they have ready access to these pictures, right? They're there. What do you mean I can't take a picture of what I'm looking at on my screen and do something with it? With this great expansion of the public domain from generative AI created images and text, et cetera, I think there's the risk of a greater perception by lay people, by average everyday people, that, oh, I can use whatever's out there. And that those are the people you can have a lot more infringement of real copyrighted works if the generative AI works are not protectable.
I see. Another question. So I prompt AI, whatever AI, ChatGPT, whatever. I prompted to make a video of Jerry Seinfeld doing something. Nothing bad, just doing something, right? And I post that on my social media, it goes viral. Now, from what you're telling me, uh, if AI produced that video, the video is not copyright protected, right? But can Jerry Seinfeld come after me because I used his image?
I would say yes,
Okay.
because there's nothing to do with copyright. Jerry Seinfeld, in this context, is the subject of the video, right? It's his image, his name that's used in this video. We're not talking about copyright. We're not talking about who owns the recorded video. We're talking about who appears in it and how it was used without authorization, right? Um, Not to mention any kind of deep fakes, right, where you put stuff into people's mouths and they don't want, they don't want to be associated with what's been said and it's a lie, etc. And I don't even, that's not my area. I don't want to go get into that right now. But he, and it's not just him, anybody, right? At least for the most part in this country, has what's called the right of publicity, their name, image, likeness rights, and can stop others from using those things commercially. There are also new laws, like there was a law that came into effect last year in Tennessee that had to do with this sort of impersonation, the use of a person's name, image, like this uh, in an AI context to regulate that. So we have new laws that are going to stop it, but we also have existing law. It's not copyright law. So the problem is we want to stick everything into one box. We want to go, oh, that AI stuff. Okay, fine, it's not copyrightable. And like that's not the end of the story because there's also, name, image, likeness rights or trademark rights, right? Other things that have exclusive rights associated with them that could still be violated even in the absence of a violation of copyrights.
All right, that makes sense. Um, Now let's take a little break from me asking you questions. Let's talk about how someone can get a hold of you if they need your help.
Sure. So, and the easiest way to find me is to go to my personal branding website, which is matthewasbell.com. Asbell's Asbell. So matthewasbell.com, which has links to my firm website. I'm at Lippis Mathias, it's a general practice law firm. Um, and I believe I also have all my social there, so you can get to my LinkedIn. I use a thing called Popple where you can connect with me in every which way, WhatsApp and WeChat, whatever works for you.
Awesome. Awesome. Now, I know that if you weren't a lawyer, you would be a musician, which you are. But let me ask you this. Do you ever uh, think maybe I should have gone to med school and finished?
Yeah, sometimes, I think it would have been useful, but it's not a regret. It's just sort of, I wonder what if. It's, I mean, it's interesting. I was also a bit frustrated by the study of medicine that, because the, from my perspective, so much of medicine had not advanced much. I mean, there are aspects which have, right? There's key aspects that have, but there were aspects of medicine that I just found very disappointing that I wanted to know more about. I mean, if anything, what was driving me into medicine was the study of the brain. I cared about perception and perceptual development. I took a class on that in college. I mean, I loved what I learned, but there's so much we don't know. And even with advances that have been made, there's still just a ton of things that I just wouldn't have been able to do. So I like also in IP, I have got greater breadth. I think what was dissatisfying for me, and maybe this would relate to people who are listening, is I didn't want to be one thing. I what I liked was innovation. I liked creativity. I liked writing a song as much as I like cooking a nice meal, as much as I like writing a story or coming up with a new invention or a new treatment for a disease. I mean, all things that I think are valuable. And it was sort of those different kinds of things that I enjoyed, that that drove me to do this. So yeah, no regrets, but I sort of wonder what if.
Right. I understand. I had a guest on and they told me that their father told them to go to law school because with a law degree, you could do whatever you want. You don't have to necessarily practice law. And that's kind of true. And if you want to do different things, I think you took the right path. Um, Now, let's talk about, you do IP, which is trademark copyright, and you're also part of Pan Bar. Um, what is one of the most, I don't want to say fun, one of the most interesting pans you help someone get?
Oh, I think that there have been some amazing innovations on the patent side that I've worked on. I think what's more interesting, I mean, I could talk about, maybe I could talk about some of those technologies. I think what's more interesting to point out is the the large proportion of innovations that people wanted to patent that were so unlikely to be protectable as patents. You get such a variation between what people perceive that they can actually own a patent on and what they pursue and what they do. Many who don't think to pursue the patent until they're too late, and on the other side, many who pursue things that are like, really, that's the thing you want to claim ownership of, and you think you can own that. Um, so it's a struggle, but I remember some cool stuff like facial recognition technologies that I had worked on a while back. That was really amazing. And I mean, it was before where things are today because I think the facial recognition's really come a long way.
That's awesome. Thank you. So I don't want to take up all your time. I know I'm on the West Coast, you're on the East Coast, but before we sign off, is there anything else you'd like to say to the viewers, the listeners, or anything you want to talk about?
I'd like to share a personal anecdote, if I may. This is not selling anything. I just think this, for me, is how it comes full circle, and it's inspiring. Um, so, um, so I, 30 years ago, had this great idea for a song. I really liked the song. I wrote the verse and the chorus, and never really got much further than that. And it sat in a drawer. It sat in a drawer for a really, really long time. I tried playing it, and tried finishing it, but just was never satisfied with it, and it was never really finished. Some 30 years later, my, at the time, 10-year-old daughter picks up the song, which I played her a little bit of, and she finishes it for me. Now, I'd much rather have that than artificial intelligence. It's awesome. Now we play it together, we sing harmonies, we have the best time, and she understands what I do for a living. So it all comes back full circle.
That's awesome. That's awesome. It was great talking to you, Matthew Asbell. We're gonna put your website, everything else in the description, but the best way to get a hold of you is to go to your website, matthewasbell.com. We'll have the link in our descriptions for everybody. It was a pleasure. I could pick your brain all day, but I don't want to take up your time. Thank you for being on the podcast. I hope you have a great day.
Thanks so much for having me.